Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant, and it is time for your daily sidebar. One of the motions that was argued today in the case against 3 men accused in the killing of Ahmaud Arbery has to do with a piece of evidence that the defense attorneys want to be excluded. The defendants recorded phone calls from behind bars. Court TV anchor Ted Rollins has the story.
I have been filleted and laid out as a sacrificial lamb. It's all political.
That is Greg McMichael talking to his brother on a recorded jailhouse call.
This narrative that we just shot a black kid for running through a white neighborhood is absolutely.
Defense attorneys want all of Greg and Travis McMichael's jailhouse conversations with family and friends excluded from trial, saying it would violate their due process rights.
You've heard the old saying, no good deed goes unpunished?
Yeah.
Well,
yeah, that's it. That's a shining example right there.
Yeah, that's right.
The defense says prosecutors will argue the good deed Greg McMichael had in mind was the killing of Ahmaud Arbery. But in a motion, they contend what Greg actually had in mind was the, quote, attempt to conduct a private person's arrest of Arbery, so police could investigate whether Arbery was responsible for a string of neighborhood burglaries. In a later call to his wife, Greg McMichael gets angry discussing his daughter's social media post, which showed a photo of Ahmaud Arbery's dead body.
She has got to stop.
She will.
Can get rid of that stuff.
Yeah.
Make it disappear. Make it go away. Because people
Yeah.
are accessing it. If not, it's liable to really screw us up.
That phone call was brought up by the prosecution at the McMichaels' bond hearing.
We had talked about the social media post by your daughter, Lindsay. That post was actually made with a picture of the crime scene while she was under your roof. Is that accurate?
That's accurate.
Okay. This becomes significant because of some of the cross-examination of Lee McMichael regarding jail calls that are captured regarding Greg McMichael actively attempting to obstruct the investigation of this case.
Many of the phone calls that Travis McMichael makes in jail are to his friend Zach, who also testified on the McMichaels' behalf during the bond hearing.
Are y'all close? You and Travis?
Yes, sir. Oh, yeah.
Okay. How close would you say that you are?
He's my best friend.
On the phone, Travis tells his friend what matters most to him.
So I'm just praying that I get a bond, where I can get out of here and raise my boy and really be able to put the nose to the grindstone.
Travis and his mother talk about how big the case has become and what lies ahead.
This is going to be a trial with the TV station, with O.J., like an O.J. Simpson trial.
Oh, my God.
But that's a good thing because they're going to see facts that's not there, that they haven't seen.
What it boils down to is 12 people going to decide what's what.
Right, exactly.
It'll be a long process, though.
All right, I want to bring in now live Court TV anchor Ted Rollins and Judge Ashley Wilcott to discuss. Good afternoon to you both. We know we have heard the defense argument against admitting those phone calls. Now we want to hear some of what the state argued today. Let's take a listen.
This call will be recorded and subject to monitoring at any time. You may begin speaking now. Thursday, May 6, 2021, 16:42, 46, Eastern Standard Time.
So, Deputy Brent, it actually says on that recorded message multiple times that the calls are being recorded, correct?
Yes, ma'am.
Okay. Now, Mr. Hope tendered the inmate handbook through you. I'm going to show you what's been tendered and admitted as Defense Exhibit 36. Go ahead and look at that.
Okay.
Now, do you see the portion there in that handbook that pertains to telephones there at the jail?
Yes, ma'am.
Can you just read that paragraph for the court, please?
Sure. Inmates will be provided access to prepaid or collect call telephones in the inmate housing areas and in the booking area. All calls made from any of the inmate phones are recorded and subject to being monitored by by GCDC staff to detect illegal activities, and information obtained in the recording may be used as evidence in court of in the court of law against you. Your usage of these phones shall constitute consent to such monitoring. The phones are computer programmed to terminate after 30 minutes. However, the length of calls are subject to change at any time. After an inmate makes one call, he or she must wait until everyone else has had an opportunity to make a call before making a second call.
All right, and so far, the judge in this case has not made any decision on those calls, says he's not inclined to issue any blanket order on calls and their admissibility. I want to ask our judge here, Judge Ashley, what you would do if you're in this judge's position, please.
Well, listen, the right to privacy when you're in jail using a phone, you know calls are being recorded, of course, your right to privacy doesn't exist. I do think, so overall, generally, I'm going to suggest that if you know they're being recorded, they're admissible. But I do think there's some exceptions. Possibly the spousal privilege exception might apply. So I may say in that particular case, those are not admissible. Others are. I think that's where I would come down with it.
Yeah, speaking of the spousal privilege exception, Ted, you were anchoring our coverage this morning when we heard the prosecution kind of conceding and saying, oh, look, we're not going to introduce that. We have no intention of bringing that into our case in chief. You know, impeachment might be another story if there's some inconsistency somewhere. And our legal analyst on the program today, Brian Dunn, made a really great point saying, you know, maybe they just thought we're going to give this one up as we're going to play along and do the right thing, so to speak, take the high road, you know, with the court, because we've got a lot more calls that we know we can introduce that are far more damaging than the one between the husband and the wife. What do you think about that, Ted?
Yeah, that makes perfect sense. 1,500 calls. I'm sure the ones that Greg McMichael was making to his wife are low on the list for them in terms of getting them in front of the jury. So sorry, I don't give that. Oh, we're not going to do that. But I thought it was interesting. The judge today was very clear in his signal to both sides. Shouldn't we wait to see what the state wants to bring in specifically before we litigate this? And the defense didn't take advantage of that. They're like, no, you don't need to know. They should all go. But they were making an argument that would have been extraordinary if they won. I mean, if the judge would have said, man, I never thought about this before. You're right. None of them come in. That would never have happened in a million years. I was shocked that they didn't take the judge up on it and say, you're right, Your Honor, we should wait till this, because they haven't told us yet, and they should. You know, they could have taken that and run with it, delay any sort of ruling. They rolled the dice, and the judge let them off the hook by saying, I'm going to take it under advisement.
Yeah, maybe a missed opportunity there. That's a really good point, Ted. Judge Ashley, what do you think?
Well, yeah, it is a good point. And the other thing that I think they can argue, they're right. If they waited to argue when they were trying to admit it into evidence and use it as evidence, there's also that fine legal point that they've been arguing of, listen, you know, they know, defendants know if they're in jail that it can be used against them if they're discussing a crime or criminal activity. And some of these don't rise to that level, but are rather discussions about, you know, wording that they use to describe what happened, but it's not necessarily describing criminal activity. So there are some nuances that I think, to Ted's point, could be argued along the way, depending on if they're trying to introduce those into evidence.
Definitely. Now, we know in day number one of this hearing, and again today, the judge heard from the defense team as they're trying to get that evidence in about prior instances where it's bad character evidence, essentially, involving instances with Ahmaud Arbery in the past prior to the date in question, and also trying to get into evidence his medical history. So we want to play a little bit of the defense arguments from today addressing those things now.
The state is citing cases to you under the umbrella of relevance to say, well, there's a lot of cases where you can attack the credibility of the witness. We're not talking about that. We are so far moved past that issue. You're hearing it now from me. It's not about the credibility of Ahmaud Arbery. And it is okay to recognize and celebrate who Ahmaud Arbery was in 2012 when he graduated high school, but it is reckless to disregard the mental health illness that plagued him for 8 years leading up to this moment in February 23rd, 2020.
Okay, Ted, I want to go to you first on this one. Julia told us a short time ago that while a lot of this, argument and testimony was coming in, with both the mental health issues being challenged and addressed, and also the evidence of various prior bad acts, that Ahmaud Arbery's mother and father, would walk out or leave, and did not want to sit there and listen to it, looked visibly upset, and understandably so. I would think they've got to feel like, hey, look, our son was killed here. And he's not the one on trial, but yet this whole 2-day event is focused on what he did in his past. Your thoughts on that, and do you think these things are going to ultimately come into evidence at trial?
No, I do think, and I know that it's illegal and not supposed to, I do think there's a little bit of jury pool tampering that's going on here. I mean, they know that people are watching this hearing and they're getting it out. And even if they don't get out the particulars, people are, he some mental, issues that he had. I wonder what that is. It's almost worse, right? To wonder what it was that they're talking about. So I think some damage is possibly done to the jury pool. I doubt that. I mean, they didn't know who he was. He didn't say a word. So they chased him around for 10 minutes. He never uttered a word. Who he was and his past had absolutely nothing to do with their pursuit and ultimately the end of that exchange. So I would be shocked if it came in.
Right, you're absolutely right. And what you said there at the end is so key about them not knowing him. Judge Ashley, I want to give you the last word here before we have to go to break. When we think of a self-defense plea by a defendant, a victim's character can come in if there was opinion evidence, reputation evidence to somebody having a reputation for being violent, being an attacker, being a bully, whatever the case may be. But the key is the defendant's got to know, and here there's no evidence to that respect. Can you see this stuff coming in, knowing that and knowing the rules so well as you do?
Well, I think that you've hit the nail on the head with the type of evidence the judge has to consider, and whether or not it's relevant, that's in his court to decide.
Yeah, they're gonna fall back on relevancy. We know that. They're gonna try to say, well, look, if it doesn't come in under this rule of character evidence with application to the self-defense plea, and that what the McMichaels did was quote unquote reasonable, they might try to say it's relevant to some other issue. I always feel like relevancy is just such a loser of an argument, and I don't see this coming in. I'm going to be stunned if it does, but we got to leave it there. We're going to talk about this more, I'm sure, in the days and weeks to come. Judge Ashley Wocott, Ted Rowlands, thank you both, and thank you for being with us at home. When we come back, we're going to be on standby to go back into the courtroom for more testimony in southern Georgia, and also continue updating you on what's happening in Minneapolis, Minnesota, with the motions hearing for the other 3 officers alleged to be involved in the killing of George Floyd.